everyone. Welcome to Save News TV. I am your host, AZ Hubbard, and I want to thank you so much for allowing us into your homes. And because, you didn't have to. That's my saying. But anyway, today we are continuing with the case of TD Jakes versus Duane Youngblood. But it is involving them. But as you might recall from the last video, we talked about the possible sanctions from the judge to Tyrone Blackburn, which is Duane Youngblood's attorney. We talked about prior to that him trying to remove himself, from the case. And today we know that he was supposed to file not today, but he filed a 15-page response as why he shouldn't be sanctioned um, for the judge to show cause. Supposed to be 15 pages. He filed 12, and then the whole filing ended up being 910 pages. Don't worry. Don't worry. We are not going through all of that. We're going to cover what his reply was, the reply from TD Jake's attorney side, and things of that nature. But it's not going to be all of that. But anyway, make sure you like, share, and subscribe. Of course, if you want to keep up with this case and catch up, the playlist will be in the comment section below, down in the description. And I want to say, even if Tyrone Blackburn is awarded off this case, whether he receives sanctions or not, I do not believe that this case is going to be over. TD Jakes has 10 John Does that have not been named, and I think he's going to follow through with this. This is an extremely long case. It's been going on, well, maybe not. It hasn't been going on a year yet. The first filing was in November of 2024, and we're going to keep up with it again. This week on the 24th, 25th, he has to show himself in court before the judge to see whether or not he's going to receive sanctions or not. We're going to keep up with this case. It is long, it is tedious, but it is also interesting. And remember, we do not have a dog in this fight. We are very adamant over here that we do not take sides in the case. We are just reporting and talking. Now, there will be commentary in it, and it might seem like sometimes it's this way or the other, but honest and truthfully, we don't have a dog in this fight. Now, some of you do. Some of you are Team TD Jake. Some of you are Team um, Duane Youngblood, and that's fine. And we welcome you over here. Just make sure you stay respectful to everybody that is in the platform. When you comment below, when you subscribe, make sure you turn on your notifications, because this case, sometimes it has a lot of moving parts, and you want to make sure you don't miss anything. With that said, with that said, please get your snacks as usual. You're going to need them because this is sort of long, even though we're not even going to go through a tenth of the 910 pages. No, sir, no, ma'am. We'll probably cover about 15 of them. No, maybe longer than that. But anyway, make sure you like, share, and subscribe. Get your snacks, get your beverage. I have my coffee as usual. As you all know, I'm avid coffee drinker. And if you are new to the page, then now you know that I'm an avid coffee drinker. So anyway, let's get to it right now. All right, I'm going to be giving some commentary in the midst of this case. And again, the playlist is going to be in the description below, so you can catch up if you have not been not caught up, or if you missed a video. So anyway, this is the memorandum of the law of Tyrone A. Blackburn Esquire in response to the court order to show cause. As you know, the judge wanted him to show cause because of the fact that there has been questionable citations on in the court filings. There has been questionable um filings, whether or not AI was used or whatever, but we're going to get a better understanding of this right now. All right. So Blackburn responds, and really, I believe that he was supposed to. He was supposed to respond on the 18th, and as you know, it was filed on the 19th. So he's already starting off in a bad light. He's a day late. Hopefully, he's not a dollar short, but maybe he is. Maybe he isn't. Again, we don't have a dog in this fight. Whatever. Okay, so preliminary statement. This memorandum is submitted in response to the court's June 28, 2025 order to show cause regarding potential violations of Federal Rule of Civil Procedure 11 in connection with the motion to dismiss and supporting memorandum filed on behalf of defendant Duane Youngblood. The undersigned respectfully submits that any errors in this cited material was a result of inadvertent misquotations and citations misattributed stemming from newly adopted product upgrades from LexisNexis and Westlaw legal research tool. While these upgrades offer efficiency, they also introduce vulnerabilities in citations and quotation process that I did not fully understand at the time of filing. Okay, so first of all, what he's saying is, listen, I had a system upgrade and I didn't understand it. And so the errors is due to the computer and not me. However, just like when you are in school, just like with anything, you know, your boss, you submit a report. At the end of the day, I don't care what product you use to input. At the end of the day, you are responsible for the output. So only thing he had to do is, go over and correct it. But it appears that he didn't. So now he's in this situation right here. Importantly, I was in the process of correcting these issues during the 21-day safe harbors period provided under Rule 11 C2 when I was involuntarily terminated as counsel. Okay, so now we know why he put in to be dismissed from the case. I did not have the opportunity to finalize and file the corrected memorandum of law despite my clear intent to do so. My termination and forced withdrawal occurred before I could complete my professional obligation to amend the record. Okay, I want to address something right now. And because I think I saw it on some channel, I'm not sure exactly what channel, and they were saying, well, he said that he quit. He filed the motion to, you know, to be dismissed. Well, that's just regular court proceedings. A lawyer cannot just quit a case, whether you're fired or whether you want to leave the case. You have to get approval from the judge. So if he was indeed fired, he would still have to submit a request to be removed from the case. And we saw that several videos back when he requested to be removed from the case. He also stated in his request that he was only removing himself from being counsel to Duane Youngblood. So if you see anybody trying to make a big issue of this, it's really not a big issue. It is just procedure. There, you just can't say, "Okay, I fired my attorney," and then because that leaves the person without representation. It has to go through the judge. A motion has to be filed that requesting removal from the case, and it has to be approved by the judge. And that's what we're at now. The judge can say, no, we're not going to let you off this case. You got to stay on this case. Or he or she can say, well, see you later. You are dismissed from the case. But whether the attorney is fired or whether the attorney wants to get off a case, whether it was their idea or whether it is the idea of the defendant or their client, either way, the judge has to do it. They have to file a motion requesting to be terminated from the case, and the judge has to approve it. So, like I said, I saw some video where they were making a big issue out of it, and it's really not. It's just simple standard procedure. And again, I'm not an attorney, so you can ask an attorney, but an attorney should, if they're, I believe this in every state. I know it is in our state that you cannot just, walk off a case or be fired and then bye bye, because there's a lot of things attached to that. But anyway, back to Blackburn's excuse of why he trying to show cause so he don't get sanctioned by the judge. Okay. I do not dispute that the motion contained editorial and citation deficiencies. However, I respectfully submit that these errors were not made in bad faith, were not intended to mislead the court, and were never intended to evade scrutiny. Doesn't matter. At the end of the day, as an attorney, you're responsible for the output and what you filed in court. That's why they have you sign um, under risk of perjury. When you file a motion, you're saying that this is correct. I don't care whether you had Chat GTP do it, whether you had a paralegal do it. It doesn't matter. What at the end of the day, you are the attorney of record, and when you sign your name, whether in person or electronically, you are responsible for that out product. So, this might be a lot of talking and gets him nowhere with the judge. Also, back to the point that he's a day late on his filing. Okay. He goes on to say, I take full responsibility for my failure to thoroughly verify quotation sources through newly adopted product upgrades for LexisNexis and Westlaw legal platforms. I acknowledge the seriousness of the court's concern. I request that those concerns be viewed in the context of the matter. This is this was a good faith effort to file a procedural sound and meritorious motion, followed by a good faith effort to correct what I later learned were citation related mistakes. As the court will see from my attachments, I have completed the research, and the cited quoted content came from actual cases. They were misattributed. See, this really, he should have did that from the beginning, and he would not be here. You know, he would not be here in this situation. So it's, again, a day late. But all right. And it's good that he's taking full responsibility, now, because some people, you know he's fessing up to, yeah, this is my fault. But still, at the end of the day, even though he's taking full responsibility, there's consequences to his actions. And we're going to see whether the judge, even though the judge is not ruling today on this, um, whether the judge accepts this as an excuse or whether he does not. Chances are he might not, especially due to the nature of this case. And if you go back, like I said, um, with in the playlist, you will see where numerous times it's been highlighted that there were errors in the case, even down to the point where the judge said, you even misquoting me, and I'm the judge. How are you going to do that and turn that back into me? So it's very obvious that Blackburn he did not do his due diligence. He was not reading. He probably was using Chat GTP. Remember, I asked that question several videos back when he did the motion. It just didn't make any sense. So, we were asking these questions amongst ourselves then. So anyway, let's get to it. The legal standard under Rule 11 imposes requirements on attorneys and parties regarding pleadings and other court filings. First, a filing must not be presented in any improper purpose, such as to harass another party. Second, the claims must be warranted by existing law or by non frivolous arguments for extending or modifying the existing law. The factual contents must have evidentiary support or be likely to have evidentiary support after discovery. Finally, before filing, the parties and their attorneys must undertake an inquiry reasonable under the circumstances to verify compliance with Rule 11's requirements. If a party violates Rule 11, the court may impose an appropriate sanction on any attorney, law firm, or party that violated Rule 11 or is responsible for the violation. And see, one thing also that's important here to note that it's not just Blackburn that could be in trouble. And as I stated on our last video, the law firm that he's practicing under because Blackburn is a licensed attorney in New York. This case is in Philadelphia, Pennsylvania. And so he is working pro hoc vice, and that means that he's working under a law firm other than his. That law firm can be held accountable for his actions. And so, this, brings this up to a totally different level. All right. In assessing Rule 11 compliance, courts in the Third Circuit, excuse me, apply an objective standard of reasonableness. The legal standard must be applied by evaluating conduct allegedly volatile with Rule 11 and reasonableness under the circumstances. This includes objective knowledge or brief at the time of the filing of challenge paper that the claim is well grounded in law and facts, consideration of the amount of time available to conduct the factual and legal investigation, the necessity for reliance on the client for the underlying factual information, and the complexity of the legal and factual issues implicated, and then several case law. All right. Rule 11 does not require perfection. Sanctions are reserved for, quote, exceptional circumstances where a claim or motion is patently, unmeritoriously, or frivolous, unquote, end quote. As the Third Circuit explained in Wharton versus the Superintendent Bradford, as officers of the court, lawyers must not mislead courts. So before they state facts, they must investigate reasonably. Rule 11b3 further affirms this duty by stating counsel must ensure that they make factual contentions that have evidentiary support, or if so specifically identified, will likely have evidentiary support after a reasonable opportunity for further investigation. Where a Rule 11 violation is found, courts have encouraged to consider non monetary sanctions, including formal reprimands or referrals to continuing legal education. So, in other words, what Blackburn is trying to do is say, hey, Judge, yeah, I made this mistake. Yeah, it was me. I did it. I apologize. But hey, even if you find that you want to sanction me, please don't put a monetary value on this. I know you said in your motion and that I could be held responsible for the attorney fees for TD Jakes doing work on these frivolous motions that you find that used improper quotations, improper law cases, and that even though I haven't admitted it, I have, might have used Chat GTP, and I'm blaming Nexus, and the other law software. But hey, don't put any financial burdens on me. Don't make me have to pay for anything that might have happened. I just want to just give me a slap on the wrist and let that be that. That's pretty much what he's saying right here. So, it is what it is. Where rule where a Rule 11 violation is found, okay, that's where he just said that. So he just want the judge to say, hey, don't give me a slap on the wrist. Don't give me any financial sanctions and send me back to school. That's really what he wants. Okay. Number 2, motion was grounded in law and fact despite citation errors. Brother, actually no, because you even quoted the judge order incorrectly. But okay, so let's read this what he has to say. The memorandum of law submitted in support of the motion to dismiss was a sincere and substantive attempt to challenge the legal sufficiency of the plaintiff's claim under established defamation and collusion precedent. The filing was not frivolous. It was rooted in binding federal and state case law. The government of the motion to dismiss was that the plaintiff, a public figure, initiated a defamation claim in federal court in response to public statements made by the defendant about his own lived experiences and religious teachings, matter that falls squarely within the protections of the First Amendment and Pennsylvania public expressions protections. These arguments were not manufactured, fabricated, or legally baseless. The legal theory advanced by the defendant, though now tainted by citation defects, was not ungrounded in fact or law. Every affirmative defense assertion in the motion was supported by authority I've researched and reviewed in good faith. The research I conducted before drafting the memorandum of law yielded over 50 authorities, including case law from federal and state courts. Research I conducted is timestamped and began on May 5th, 2025. So he started doing his research and everything. Everything was done on May 5th, 2025. He said, I reviewed and downloaded those sources using my newly upgraded Nexus Lexus Protege and Westlaw Next co-counsel accounts. So he's saying, on May 5th, this is when all of this started happening, the citations and everything. But I think I recall it might have been before that, but I could be mistaken. All right. Although I later learned that the formatting and tagging mechanisms of these modernized legal research tools created quotation artifacts, at no point was there an intent to deceive the court or fabricate authority. The legal foundation of the motion it was sound. The formatting and attribution process was flawed. I respectfully submit that the court's inquiry should focus not only on the surface level citations deficiencies, but also on whether the motion to dismiss, despite its editorial flaws, advance a good faith argument grounded in fact and law. So again, he is standing on the ground of Hey, it was all in good faith. Efforts were underway to correct the record when I was forcefully removed from the case. Okay, on June 17th, 2025, I received a letter from the plaintiff's counsel identifying perceived violations of Rule 11 and evoking the 21-day safe harbor provision under Rule 11C2. That same week, I began a comprehensive review of the memorandum of law to remove or correct any problematic quotations, citations, or formatting issues. I filed I plan to file an amended version that preserve the substances of the motion but corrected the inadvertent quotation misuses and sources. Okay. So, um he says that was on June 17th. Okay. Let me check something right quick. Let me check something right quick. June 17th. Okay. So there was no filings. He filed his motion to leave for leave to file. Okay. That was totally different. He filed his motion to withdraw. Let's see, what's day? Okay, he filed his motion to withdraw as attorney on June 25th. So on the 17th, he was notified that there was errors and problems with the filing. That's according to him. So according to him, he had only been working on 6 days of the 21 days that he had to correct the errors. This is according to his explanation here. The process was not delayed or avoided. I had every intention of completing it within the 21-day window. Unfortunately, before I could complete and file the corrected memorandum, I was involuntarily terminated as counsel via email by defendant Duane Youngblood at 10:28 p.m. on June 23rd. The very next day, on June 24th, 2025, I received an email from the defendant's local counsel directing me to sign and return a pre-drafted notice of withdrawal. I was given no opportunity to discuss the Rule 11 issues with the client or local counsel, nor was I given a chance to explain the corrective work was already in progress. My withdrawal was not strategic. It was not the way to avoid responsibility. It was a consequence of the client relationship that had come to a sudden and unexpected end. I had every intentions of remaining in the case and completing the corrective process. The fact that I was unable to do so is beyond my control. Okay, so he was fired on June 23rd by Duane Youngblood, according to him. On the 24th, he received a pre-drafted notice to withdraw. So it probably came from the attorneys at hand. On the 25th of June, that particular his motion to withdraw as attorney was filed on the 25th. Now, even though he received a pre-drafted letter, he still could have communicated the problems with the case. He what kept him from doing that to with the attorney? That's what I want to know. How does that keep him from doing that with the attorney? So let me see. Let me put this up here so you can see for yourself that he filed this on the 25th. I'm just gonna put just this part here. Okay. So he put that on the 25th, as you can see on the screen. So, he still had an opportunity to let them know that there was problems with the filing. I don't did his mouth shut up, seal shut when he did that? That's what I want to know. All right. Misattributions were caused by emerging legal technology, not malice. The citation and quotation errors identified by plaintiff's counsel and tagged in and flagged in court order to show cause arose in part from my adoption of upgraded legal research platforms, LexisNexis Protege, Westlaw Next Co-Counsel. These tools were marketed to me as solutions for solo practitioners who manage high caseloads without the support staff. They promise to streamline research, expedite drafting, and offer integrated support for site checking and case analysis. Yes, that all might be true, but at the end of the day, he still has to verify everything that's in his cases. You can't just file something hoping that the, you know, software is going to be 100% accurate, because the software cannot be sanctioned in court. Only you can. So, while it all sounds good, he still, at the end of the day, is responsible for what he puts, the motions he files in court and what he signs. But the motion goes on to say, admittedly, I was excited to have access to technology that could reduce the time required for legal research and writing by nearly half. Yes, it can, but you still have to verify. Even though it reduces writing time, does not mean that it is accurate. You still have to verify this, man. Come on now. 60% of my work is pro bono, and at times I do not have enough hours in a day to complete all the tasks required of me. Well, that's on you. I understand that you're doing things pro bono, and that is absolutely admirable of you to do that. But then maybe you need to cut back on the number of cases that you accept if it is in the part of you not being thorough. And although you say it's pro bono, um, it might be pro bono, but contingent upon if there is a settlement reached and there's financial gain, then do you take a percentage of the winnings if they win? Is that how your pro bono work? The question is there an agreement prior to this that you would receive money from these cases? I don't know. That's a high percentage, 60% being pro bono if you don't expect to be paid. I that's really almost unbelievable. What do you all think? Get in the comments. Tell me what you all think of 60% of his business being free. You know. Okay. All right. All right. It is difficult to find co-counsel to assist with the work I do because, quite frankly, no one wants to work for free. Okay. My firm routinely handles civil rights, employment, SA, and medical malpractice matters for clients who are indigent, unemployed, or recovering from debilitating trauma. In the case at hand, I provided the defendant with pro bono legal services for nearly 9 months. But all these cases, types of cases that you listed, even though it's pro bono, you say you're calling it, seem to be calling it pro bono, but it's contingent of if they win, if they prevail in their case, then you receive a percentage of the winnings. In North Carolina is 33 and a third percent. Elsewhere it could be, different percentages. Or it could have gone up in North Carolina, or it could be contingent upon what type of deal you struck with the plaintiffs. But to say it's pro bono, that just proves that you have to be a good attorney. And everybody is not going to settle cases. You have to be not just an attorney, but you have to also be willing to go to court on these cases. And what is appearing to be is that he's taking these, like you say, you send in a demand letter and you want to settle it before it even becomes a case. And that's the case, what happened with the 6 million of standard procedure. Well, if that doesn't happen, then you got to be prepared to go to court. And when you go to court, all of those expenses piles up and are on you. So you have to be a good trial attorney. If you're not a good trial attorney and you out here in these legal streets trying to go to trial, you better make sure all your ducks in a row. And it appears, allegedly, according to the filing and according to what the judge said and according to his own admission, that his trial game wasn't at 100%, at least in this case. I don't know about other cases, I haven't followed them, but he wasn't on his trial game when it came to filing these motions. All right. Although I utilized the citation review features included with the upgraded platforms, I now understand that I initially misinterpreted how these tools handled paraphrasing text and inserted quotation marks. I failed to independently confirm that the quotation formatting matched the underlying source material in every instance. There you go. There you go. That's it. You didn't do your job. You didn't, edit, double check it. Also, when you're filing stuff, you have to make sure it's in your language. Remember, when we were talking about in previous videos on regarding this case and other cases, how we like the writing styles or dislike the writing styles of attorneys. And if you're using and dependent on software to do your motions, it loses the style of the attorney. It doesn't have a style. It doesn't speak to what the attorney can argue if he has to go to court. Again, your trial game. If your motions are speaking one language and then you get in front of the court and you speak in another language, as far as style goes, something's going to be lost in the mix. At least that's my opinion. Okay. All right. He goes on to say, I did my due diligence to best of my understanding. Okay. Wait a minute. I missed the part. Okay, he goes on to say, when I said about this, he says, that failure was mine alone, but it was a technological and editorial error, not an act of deception or an attempt to defraud the court. Okay, so you're taking responsibility, but still it's a technology and editorial error. I think it's more of an editorial error than a technology error. Okay. User error. But it's up to you to edit, not the software. But anyway, that's just my opinion. He says, I did my due diligence to the best of my understanding. I read the document thoroughly before filing it, ran the citation review feature, and cross checked the sources. Okay, if you cross check the sources, why didn't you notice that then? Okay, but he says, still mistakes remain. Yeah. I deeply regret that the errors survived my review. Okay. He says, I deeply regret that the errors survived my review, but I asked the court view them in light of the tools that caused them and my good faith reliance on platforms that I still am learning to use. This is an expensive lesson. You learning to use this at the expense of your client. Okay. All right. Specific response to quotation concerns raised in the order. The court's order to show cause specifically questioned the accuracy of several quotations, including attributions of Costanello and versus Scranton Times and the other Pennsylvania cases. I take full responsibility for each of the challenge quotations and acknowledge that some were imprecise paraphrases, mistakenly enclosed in quotation marks, while others was misattributed due to errors during the drafting and formatting. At the time, I understood that all I had to do was to highlight the section of the cases and authorities I researched and wanted to use, upload the case and authorities, as well as supporting materials, complaint, court orders, and opinion, and any relevant transcripts with written instructions, and the upgrade legal research platforms would extract the information and draft the requested documents. I was wrong. Now, here's the thing that I don't know whether the judge will pick up on, but this is key right here. He says, he uploaded all of this part here with written instruction. That means that if he prompted that software, if he used a prompt, that software did not give the output that he wanted. There could be most likely an error in the prompt that he put into the software to get these results that he got. So, it's it is what it is. He says he was wrong. And that is true. And when you using Chat GTP and when you using these softwares and everything of this nature, you have to put in the correct prompt in order to get the right output. So your instructions to AI has to be exact in order to get the exact results that you want. That's why it's critical to check and double check the output of what you receive. For example, the challenge language in Costanello and versus Stranham Times was not fabricated, but rather paraphrased from Pennsylvania case law cases cited in other jurisdictional opinions. Challenge one quote, an intent to injure. The language was paraphrased from RB versus Holleberg report and recommendation adopted, which in turn cited Thompson Cole versus Pike Cole. Proof of malice, i.e., an intent to injure, is essential in proof of conspiracy. Challenge two. To sustain a claim for civil conspiracy, a plaintiff must demonstrate malice conduct. This paraphrase was drawn from Jones versus Johnson and Johnson, which stated that the plaintiff must prove that the defendant acted with malicious intent to injure. While the original intent was streamlined legal standards in the reader friendly format, I understand that paraphrases, particularly those closely tracking the language from cases, must never be enclosed in quotation marks unless they accurately reflect the precise language of the cited source. In this instance, I failed to meet that standard. However, the underlying authorities that support legal propositions were real cases I reviewed, highlighted during my research, and accurately reflected the substantive requirements for civil conspiracy under Pennsylvania law. None of these paraphrases were invented or drawn from fictitious cases. Instead, the problem lay in the way they were formatted and attributed. From now on, I understand that this level of precision must be maintained even in time constrained or high volume litigation settings. So, my question is, he's just realizing this. How long has he been an attorney? Does anybody know? Um, Let me see. How long has Tyrone Blackburn been an attorney? Let's see if I can pull this up and see. Um, it states that he became an attorney in 2018. Let's see. Tyrone Blackburn, registrant 5619416, is an attorney in New York, admitted to New York State in 2018. Registered with the Office of Court Administration of New York State Unified Court. An employer is T.A. Blackburn Law PLLC. The attorney graduated from Staten Hall University School of Law. The registered office, and that's the address, contact information. So he's been an attorney since 2018. So that's a lot of years for him to being just realizing just realizing this. What's that? 4, 8, 9 years. He's been an attorney 9 years and he's just realizing this. Really? Okay. He must have all of his cases must have ended up in settlements. And this must have been his only or major trial case, because it's just hard to believe he's been an attorney. No, not 9 years, 7 years. My bad, my math. um he's been an attorney that long and he is just realizing this. That's crazy. That's crazy work. Good faith mitigating factors and candor regarding optics of withdrawal. I fully acknowledge that from the court vantage point, the circumstances surrounding the filing of the motion to dismiss and my subsequent withdrawal as counsel may appear to be reflective reflect an intent to deflect responsibility for filing the contained significant citation errors. This absence of any immediate corrections or clarification followed by my departure from this case creates an understandable and compelling inference of bad faith. The court is justified in viewing this sequence of events as problematic and as potentially evidencing a deliberate attempt to escape liability. But everything is not what it seems. Okay. As previously stated, upon receiving the Rule 11 safe harbor letter from the plaintiff's counsel, I immediately began the process of correcting the record consistent with my obligations under Rule 11C2. My plan was straightforward: to remove all quotation marks around para- paraph- mm, paraphrase or impressive citations, correct misattributions, and ensure that every statement of law or fact was sourced correctly. I had no intention whatsoever to abandon the filing or to evade the correction process. To the contrary, I took the allegations seriously and already begun implementing changes. I did not seek to withdraw. I was involuntarily terminated by my client and instructed by local counsel to file a withdrawal prepared by them without any discussion about pending Rule 11 issues or the correction process I had undertaken. Again, he still could have voice his concerns and let them know there was issues with the case when he received that. I mean, why he wouldn't do that? This is a very serious thing. Um, is beyond me. I don't know if you all have any idea why he couldn't have at least let them know, responded to the email and say, listen, I have no problem with withdrawing from the case, but there are issues with the citations according to Rule 11. Um, I just don't understand why he could not have done that. Make sure you comment in the comment section, like, share, and subscribe while you're doing that, and turn on your notifications. Okay. Had I been given a few more days, I would have filed the corrected memorandum. I gained nothing by misleading the court. This case was never about evasion or deception. I always acted in earnest, and my singular goal has been to help the defendant defend what I still believe is his constitutional protected right to speak about his lived experiences. On October 2024 through June 23rd, 2025, I dedicated myself to this case. I spoke with witnesses, conducted extensive research, drafted motions, and responded to numerous filings, all without compensation and assistance from a paralegal or associate. The anti SLAPP motion I filed earlier in the case did not contain similar issues for attribution. That motion reflected the same commitment to accuracy and advocacy that I brought to the motion to dismiss, but without the complications introduced by the newly adopted technology. At the time I was removed, I had every intentions of remaining in the case and continuing to represent the defendant for free. My commitment to this matter was never driven by financial gain. It was rooted in a genuine belief that the lawsuit was an impersonable attempt to shield the defendant's First Amendment right. My work was focused entirely on helping the defendant fight what I understood to be defamation claim brought in bad faith for the purpose of silencing his public account of lived experiences. The court's concern is serious and warranted, but I ask only that they be evaluated with full context in mind. I did not abandon my ethical responsibility to correct these errors. I was deprived of the opportunity to fulfill them. Conclusion: I respectfully submit this memorandum not to excuse or minimize the citation errors that appeared in the motion to dismiss memorandum of law, but to candidly explain the circumstances surrounding them and to reaffirm my professional commitment to the integrity of the court. The filing of this at the filing at issue was never intended to mislead. The substance of this motion was grounded in legal authority, which I researched, downloaded, and reviewed. The citation and quotation issues were not a result of fraud or deception, rather than the intended byproduct of transitioning the modernized legal research tools specifically marked to solo practitioners like me who lack staff, paralegals, or associates to rely on. I misunderstood the output of the tools and failed to catch formatting and attribution errors. And for that, I accept full responsibility. I attempted to make immediate steps to correct the record upon receiving the 21-day Rule 11 letter from opposing counsel. I intend to file the corrected memorandum that preserve the substance of the motion while addressing the citations concerns, just as Rule 11 contemplates. However, I was involuntarily terminated by my client before I could complete the process. I did not choose to abandon the case or to correct or avoid correcting the record. I was denied the opportunity to do so. I understand the seriousness of the court's concern, and I fully appreciate why the optics of this withdrawal without correction could raise questions. But I assure the court that my actions were not driven by malice, evasion, or disrespect, but were the result of confluence of events. My goal is to demonstrate that I was engaged in good faith throughout, that I was actively trying to correct the fouling, and that I remain committed to the standards of candor and responsibility required by Rule 11. I respectfully request that this court consider the totality of the circumstances when deliberating on whether to impose sanctions. Well, it appears that he is most definitely throwing himself on the mercy of the court and taking responsibility for what has transpired. But I don't know if that's going to be good enough. Just like I stated earlier, his filing is a day late, and his excuses now, based on what I've read, might be $1 short. So now we're going to go on to the next portion of this, and we're going to talk about the response from Jake's attorney. Okay, so now we're going to go quickly over his affidavit in response to what we just read. And this is really short here. Let's see what he says. It's going to pretty much cover the same things he said before, but this is just his affidavit that he's a licensed attorney in the state of New York, admitted to practice before the court, and he submitted his affidavit in response to the court order to show cause dated June 26, 2025, concerning citation issues identified in defendant's Duane Youngblood memorandum of the law in support of his motion to dismiss. He take this matter extremely serious. You have practiced law since 2018, and during that time, I have encountered citations. I have never encountered citations or quotation issues in any legal filing submitted to the court. I think he has, but we'll see. We got more to go on this. There's more information coming forward. This is the first instance of its kind in my professional career. I have always respected the significance of Rule 11 and my duty imposed on attorneys to ensure the accuracy, factual foundation, and legal grounding of each filing. Upon receipt of Rule 11 Safe Harbor letter from Plaintiff's Counsel dated June 17th, 2025, I immediately began reviewing and revising the memorandum of law in question. I removed the quotation marks from the paraphrase legal statements. I rechecked the case citations and began compiling a revised version of the memorandum. This version retained the motion's argument while correcting the citation and quotation errors. See attached. However, before I could finish and file the updated documents, my client ended my agreement on June 23rd. The following day, on June 24th, I received an email from local counsel directing me to execute and file a notice of withdrawal, which they had prepared. See the exhibit. We also went over that earlier in this video. He filed it on June 25th. Number 5, the citation issues were not a result of bad faith and intent to mislead the court. Instead, they stem from the recent adoption of upgraded legal research tool LexisNexis Protege and Westlaw Co-Counsel, designed to assist solo practitioners. These tools generated suggestions and citation fields that I mistakenly incorporated without fully verifying the quotations and formatting and attribution. Number 6, unwisely, I unquestionably trusted the accuracy of these platforms, having used them throughout my law school and professional career. These platforms are at the vanguard of the legal profession, so much so I was a LexisNexis representative in law school. I had no reason to doubt the accuracy of this product. Okay, so it sounds like he is really familiar with LexisNexis. And let me get me some water because this has been a lot of reading, even though I did just take a little break. But it's a lot of reading. You all know I love you, and I do appreciate you. Make sure you like, share, and subscribe. Okay. Number 7, one of the issues raised in the court's order to show cause concerned the citation to and quotation of the court's April 25th, 2025 memorandum opinion denying defendant's anti-SLAPP motion. I acknowledge that the motion to dismiss memorandum inadvertently quoted and paraphrased language from that opinion as though it were a verbatim quote. This error resulted from my misuse of the upgraded legal research tool, which permit users to upload source materials and automatically generate text for integration. Okay, so now even let's say he didn't know the law, verbatim, and he was using, as he uses tools. So okay, maybe something got misquoted, maybe he missed checking one or two, but he was in the courtroom. He read the opinion, the decision by the court. So how do you misquote that when you were there? So that just tells me, my personal opinion is that maybe he didn't read the whole opinion of the court. Because if he had read the opinion from the judge rulings, then he would have known if he proofread um, the motion to dismiss that he submitted, that didn't happen at all, and that was not at all what the judge said. I'm just asking. You all have been following and with this case with me, and so you tell me if I'm wrong or whatever. But you know, number 8, I uploaded the court's anti-SLAPP opinion and allowed the system to assist in synthesizing the court's reasoning. However, I failed to distinguish between paraphrased content and quoted material properly. There is no excuse for this error, and I regret that it gave the appearance of misrepresenting the court's ruling. Okay, just like I said, I mean, there's just absolutely no reason for that. you know, only thing I can surmise is that you didn't read what the judge said when he, in his ruling. Maybe I'm wrong. If you all think I'm wrong, tell me. But even he agrees with that. Okay, number 9. At no time was there any intent to deceive or mislead. The prior anti-SLAPP motion, which was manually drafted and filed without the use of the upgraded version of the legal research tool, contained no such errors. I respectfully ask the court to view the misquotation not as a product of bad faith, but as the unintended consequences of integrating an unfamiliar tool into my workflow. 10. I had already corrected and removed several citations and paraphrased statements identified in the safe harbor letter and intended to file the corrected memorandum within the 21-day window. I was not allowed to do so by my abrupt and involuntary termination. Again, back to what I said earlier. Why when he was terminated and he spoke with the attorneys as far as getting the letter that they wrote for him to dismiss himself from the case. Why didn't he let them know that there was problems with the case in which, the citations and everything? This is beyond me. Number 11, I have since conducted a thorough audit of all active case filings generated using these upgraded subscriptions and have begun correcting any citations or formatted errors identified through that audit. 12. In addition to the audit, I have completed continuing education courses to better understand the implications of artificial intelligence in legal drafting, including ABA. AI is changing the legal profession, but not your ethical duty. 2. Complete your CLE request and program evaluation, catching up to AI ethically. How to how the existing ethic rules apply to artificial intelligence, and how to guide lawyers in avoiding ethical pitfalls. And 3, TRCLE, Artificial Intelligence and Legal Practice. I have also registered for additional CLE addressing AI ethics, legal research accuracy, and best practices for solo practitioners. Okay, so in other words, he's showing the judge that, when he asks not to be held accountable financially, just, give me, you know, send me to school, give me a slap on the wrist, and, make me take some courses to update myself. So he's showing the judge that, yeah, this is what I've done to do that. Okay, number 13, I respectfully refer the court to my prior affidavit in support of the defendant's motion to dismiss, which provides more detailed information about my research process and the use of the upgraded legal tools. That filing and the motion itself were supported by over 50 legal authorities that I reviewed starting May 5th, 2025. He has an attachment. The quotation and the citation errors were never intentional. I understand the optics of the timing being removed from the case before filing corrections, but I did not withdraw voluntarily, nor did I ignore the obligation imposed under Rule 11. Number 15, I request that the court consider my clean record, which is questionable. I think he has some things. The significant steps I have taken to rectify my actions, my adherence to ongoing education requirements, and absence of any malicious intent. I am committed to upholding honest and diligence as an officer of the court. I hereby declare under penalty of perjury that the above statements are true and accurate. Okay, that is his thing. He includes Exhibit A, which is the letter that T.D. Jakes' attorney wrote to him. And he says he's writing on behalf of T.D. Jakes concerning your conduct in representing Duane Youngblood in the above referenced case. This letter constitutes service of the plaintiff's motion for sanctions and documents support in accordance to Rule 11 and provided the federal rule. Plaintiff intends to file a motion for sanctions with the court by ECF within 21 days after service of the motion as provided Rule 11CA. Plaintiff's motion seeks sanctions based on your misconduct in signing and filing pleadings for defendant's motion to dismiss, specifically the Memorandum of Law, ECF 43, and Reply ECF 46. The plaintiff intends to file a motion for sanctions unless defendant immediately withdraws his motion to dismiss, file a notification to the court explaining the circumstances of false citations and statements noted in the motion of sanctions, and formally retracts the statements about plaintiff and his counsel noted in the motion. Please advise within 21 days whether defendant will comply. And this was done on June the 17th, 2025. Okay, so now TD Jake's attorney filed their motion for sanctions against Tyrone Blackburn, Youngblood's attorney. So as you can see, we looked at exhibit A, we just read the letter. Okay. And although this is several pages, here 71, and then like I said, the whole thing was 910 pages. We're definitely not going to go over all of that. And we're not going to go over all of this either. We're going to read a few keynote things and then we're going to call it quits. If you want a copy of this, you know how to hit me up. Email, make sure you like, share, and subscribe. Comment below. Okay. And let me know what you're thinking. Okay. So TD Jakes' attorney came back and said, hold up, we want sanctions, and this is why. So they go on with pursuant rule to Federal Rule of Civil Procedure 11C. Plaintiff Thomas Dexter Jakes respectfully moved for sanctions against defendant Duane Youngblood's counsel, Tyrone A. Blackburn, for filing briefs replete with false factual contentions, fabricated quotations, and gross misrepresentation of case law and the record, conduct that violates the standards imposed by Rule 11B, specifically one. On May 5th, 2025, defendant Youngblood, through his counsel, filed a motion to dismiss and a memorandum of law. Number two, the opening brief falsely attributed language and findings to this court's April 25th, 2025 memorandum opinion, including that this court had already observed plaintiff's complaint to be repetitive and heavy on rhetoric and lacking factual detail, supporting the elements of the plaintiff's claim. In reality, no such finding or observations were made by the court. Three, the opening brief mischaracterized numerous of judicial decisions too, citing them for propositions that the cases either did not support or outright contradicted, and in many instances, fabricating quotes that do not appear anywhere in the citations cited opinions. Number four, the opening brief also made false representations about the complaint's content, representing that it does not contain various factual allegations that it plainly does. Excuse me. Number five, plaintiff identified these misstatements in detail, providing specific examples of the fabricated quotations and misrepresentation in his opposition ECF number 45, rather than correcting or withdrawing the misrepresentations upon notice. Defendant's counsel doubled down in his reply on ECF number 46. Remember, everybody, we already read those. You can go back into the playlist, which is down below. If you want to catch up, we went through those, this particular one. And as if you've been keeping up with this, you clearly remember that he was doubling down on things, even though the TD Jakes, his attorneys, was saying, hold up, this is inaccurate, this is false representation of the citations, etc., in their motions. But again, um, he continued to double down and continued to um, hold those positions as true until this happened. This particular motion happened as far as requesting sanctions. Number 6, the reply continued to misrepresent case law and also falsely accused plaintiff of misquotations and other legal inaccuracies, supporting this claim with LexisNexis quote check report that he failed to submit to the court and that plaintiff disproved through manual review as detailed in his SIR reply, ECF number 51. Number 7, counsel's conduct is not excused by any suggestion of inadvertence. The failure to withdraw or correct the material falsehoods after plaintiff first raised the issue in his opposition and again in his SIR reply demonstrates the deliberate disregard for counsel's obligation under Rule 11. And many of the false quotes do not appear in any legal source and are not found nowhere online except the defendant's own brief. Facts that make their fabrication unthinkable. Number 8, moreover, counsel for the defendant had recently been admonished by another federal judge. I remembered him being admonished by other judges. And so let's see. But we were not following those cases, so I did not have any clear details. So let's read what the admonishment was. Moreover, counsel for the defendant had already been admonished by another federal judge in the Jones versus Combs, which this is John Sean Combs P. Diddy case. Numbers, you give the case number, for making misrepresentations of the law. Okay, so we just read that Blackburn said, "Oh, judge, this has never happened before." But now we see, according to this pleading for requesting sanctions against him, he just, because the Combs case just got over, Jones versus Combs, that he was making misrepresentations of the law. He is also subject to pending disciplinary referral in the Southern District of New York. See Zunderskovicki Ski versus Fisher on April 3rd, 2024. Wow, it sounds like Blackburn be having some issues here. All of the foregoing conduct rules 11B2 and 11B3, which require counsel to ensure factual contentions have evidentiary support and that legal contentions are warranted by law. Given the severity, sanctions are warranted to deter further misconduct and uphold integrity of these proceedings. Accordingly, plaintiff respectfully requests that the court impose sanctions against Youngblood's counsel, Tyrone Blackburn, pursuant of Rule 11C as follows. A. Award plaintiff all reasonable attorney fees and costs incurred in responding to the motion to dismiss, drafting and filing the motion to leave to file a SIR reply and the SIR reply itself, and preparing the motion for sanctions, including but not limited to the fees and costs incurred to discover and address each of Blackburn's false representations, misrepresentations, and false accusations in his motion to dismiss papers. And B, impose any other sanctions the courts deem just and appropriate under Rule 11C4, including referral to the court's disciplinary committee. Woo! This motion find support in accompanying memorandum of law, the declaration of Dustin Pursh, and exhibits here thereunto. Wow. Just wow. That is a lot of money. Now, TD Jakes has some high powered, expensive attorneys. And we know that this is going to cost a real pretty penny. if the judge allows it. And we have reason to believe that the judge will allow the cost to be levied against Blackburn if the judge decides to sanction him, because when we read the order from the judge for cause for Blackburn to show cause, that these were some of the things that he said that he would do. And so now you have Blackburn in a situation where he might have to incur a lot of costs. And I would think conservatively looking at this, probably at least $50,000 to $100,000 worth of costs. Not include, it could be more. When you think of, they want the costs, attorney's fees and costs incurred for responding to the motion to dismiss, drafting and filing the motion for leave to file the reply and the reply itself, preparing for the motion of sanctions, including but not limited to fees and costs to discover and address each of Blackburn's each. So however many he put in there, they want the cost and discovery of each of Blackburn's false representations, misrepresentations, and false accusations. So you're looking at however many attorneys had to work on the case. You're looking at the attorney's fees per hour. You're looking at the paralegals fees per hour. Remember, he just said that they researched and to highlight the misrepresented, and they did that manually. Let's see if I can find this real quick up here. But I just read it that they did it manually. So to find these misquotes, where is it? Yeah. Yeah, they did it manually. Well, I just read it. But anyway, so that's a lot of attorney's fees, a lot of hours, and any other thing, the cost of discovery, the costs associated with discovery. So it probably would be conservatively at least $50,000 minimum um for him to be fined. Plus they're coming after his throat. So if the judge want to um take his license, they're coming after him. Deep throat, you know, all full force. They want everything. So now the 24th, since they want this, they're gonna have to appear in court, the attorneys, um, along with Blackburn this week. And we're gonna cover that once we get that information. And today is not the 24th, has not happened yet. And so it is on and popping. So let's get to the next part of this, because it is definitely one and done for um Blackburn if the judge rules against him. Okay, so they go on to bring in more information about this. This is a long case, and like I stated, we're not going to go through all of this because this video is getting long enough. I want you all to have the gist of it. They have a whole table of contents, relevant facts, legal standard, the argument, and they go through all of this, the false claims about the court's order violate rule 11b2 or 11b3, the misrepresentation of judicial opinions, Blackburn violated rule, the claims about plaintiff counsel and opposition violated rule, the false claim about complaint violate rule, and severe sanctions against Blackburn is warranted. So they went through all of this. We're not going to read all this. I'm going to skip through this. I want to go. to this part here because we've pretty much through all of this covered where he's made his thing. They're alleging, why sanctions is necessary. So let's go to the part where it says severe sanctions against Blackburn is warranted. This case calls for strong sanctions for several reasons. First, the conduct is beyond egregious and made in bad faith. Blackburn submitted two briefs full of probable and blatantly false misrepresentations about the law and the record, including by this very court in this very case. Second, Blackburn's conduct was particularly culpable because he received prior warnings from courts and notice of the widespread fabrications and errors in his opening brief. It goes Wharton and then the 95 F4th at 150. Counsel should have investigated fully and given the court all the facts or at least admitted the earlier on sites. Instead, they doubled down. In April 2024, Blackburn was found to have violated Rule 11 but was not sanctioned. Even though the court observed at the time that his failure to conduct the investigation required by Rule 11 appears to be a pattern at the Southern District of New York on April 3rd, 2024. Instead, the court referred Blackburn to the Southern SDNY, which is the Southern District of New York Grievance Committee. In March 2025, less than 2 months before the filing of the opening brief, another federal court issued a warning to counsel because Blackburn's filings are replete with inaccurate statements of the law that were not just disturbing, but shocking. Wow. Not just disturbing, but shocking. And this is in the Jones versus Combs case in the Southern District of New York on March 24th, 2024. The court reminded Blackburn that he has a professional obligation to state law accurately. In light of the warnings he's received previously, the court found much of Blackburn's conduct regarding the defendant's motion to dismiss to be unsettling. For most lawyers, these admon- admonish- uh, admonishments would make an impression and cause them to clean up their act. Not Blackburn. He finally defiantly drafted, signed, and filed the opening brief with all these falsities. Again, we talk about the attorney's style of writing, and that's what I was saying as far as making sure, as we read this, we enjoy the style of the writing of the attorneys, and we don't have a dog. Save News doesn't have a dog in this fight. You all might be pulling for one team or another, but I enjoy a good writing of law. Okay. Then came plaintiff's opposition with highlighted the issues with Blackburn's submission and put him on notice of his falsehoods, misrepresentations, and overt errors. When confronted with wild inaccuracies in their briefing, most lawyers admit their wrongdoing. Not Blackburn. I mean, they dragging him for filth. He failed to correct the record or engage with the substantial inaccuracies at all. Instead, he went on the offensive, turning his ire to plaintiff and falsely accusing plaintiff counsel of engaging in the same reckless conduct he was. The courts agreed more severe sanctions are warranted when the litigant fails to take responsibility for misrepresentation. That counsel was already on notice that his pleadings contained overt errors, makes these violations even more egregious. Blackburn has not only failed to take responsibility, he doubled down on his disregard for ethics and basic decency. Whether the improper conduct was willful or neglect may bear on what the sanction should be. Third, the baseless filings, like the ones Blackburn submitted in this case, put the machinery in the justice in motion, burdening courts and individuals alike with needless expense and delay. Further, many harms flow from the submission of fake opinions. The opposing party wastes time and money in exposing the deception. The court time is taken from other important endeavors. The client may be deprived of arguments based on authentic judicial precedents, and it promotes cynicism about the legal profession and the American judicial system. Accordingly, strong sanctions are warranted to deter further misconduct and uphold the integrity of these proceedings. Plaintiff respectfully requests that the court sanctions Blackburn under Rule 11C as follows. And we just read it, said the same thing. So they definitely want sanctions. Okay. They want the sanctions. And now this is the support of the sanctions um about the motion to dismiss. So they're just going over and following through all of the same things that we and then they're highlighting the case law that was misrepresented. So I wanted to go over one last part before we because it's just it is really a lot that they're saying that Blackburn has misrepresented into the court. So let's go over this last part. There's a couple of emails I want to check on with. Okay, so I wanted this. I skipped down to this email, and this is an email from Duane Youngblood to Tyrone Blackburn, and wanted to go over this. And he says, and I blacked out the email addresses. Hello, Tyrone. This is what Duane Youngblood is saying to Tyrone Blackburn. Hello, Tyrone. I wanted to speak with you and email you about all this Jake's case stuff. Today I met with attorney Ellis and he shared the potential filings that Jake's attorney will file a 21 days if you do not drop the motion to dismiss and then explain to the court why you did it. You have been nothing but a blessing to me. I in no way could let you do that. You told me that you are preparing to refile the motion. I do not want you to do that. I don't want you to in any way hurt in all of this. Okay. I am concerned that this judge may do something that I would not like to you, and that this could also impact the case. I talked with Anthony Ellis, and they told me that they would have to separate from you, and that I could decide what was best for me. I have decided that it is best that I allow you to be removed from the case. I do not want you to have to tell the judge anything about anything. Okay, so as you see this, the date on this is June 23rd, 2025. Paul showed me the two cases they will cite and what the federal judges said about you and your mentions in their documents. I think this is very upsetting. I know you understand the law and that would and what you should be doing. Ooh. I do not sit in any judgment because I know It is the best interest of Jake's attorneys to make you look as bad as they can. I know you will have to write the court to withdraw yourself. You have been a blessing to me, and I will continue to do my best to be one to you. I know you are in many battles. Tyrone, please be careful as you proceed. Many are trying to discredit you because the cases you represent. Do whatever you need to do to make all of your emotions and filings are on point. Your heart is pure and so good. Please do not hurt the greatness God has given you. Again, thank you for all you did. I really thank God for you. I will allow Sumner Law Group to represent me in this and hope it will end soon. I would still like to chat with you from time to time. Well, honestly, I don't believe that this is going to end anytime soon. Um, I don't think this is going to end anytime soon. I think Jakes is going to continue to pull this forward. So let's read the next email. Okay, so then Duane Youngblood writes Paul, who is of the Sumner Group, and he says, "Oh, let's see. Wait one second. Make sure I got my right mic on, child. Woo." He says, "Hello, Paul. I am writing to let you know that I have decided to move forward with the Sumner Law Group with my legal representation and the current court case in federal court that you and Attorney Blackburn have both been on. I called Attorney Blackburn, left a message, and emailed him. Did not get to speak as of this email, but we will. To let him know that I had met with you and had gone over all of the current pressing issues of this case. I informed him of my great appreciation for all that he has done for me since we met. I also informed him that I would be moving on from his services as they are no longer be required on this case. I do not know all the legal responsibilities, but I am doing what I know to do, which is to notify you as I notified him. I have included Attorney Blackburn's in this email as well. I really hate all of this and hope the case can close out sooner than later. I will await whatever has happened at the court for Sumner Law Group to be my only representation on this case. I thank you for all that you have done and will do. And I thank Attorney Blackburn for being in my corner during the toughest days of 2024 and 2025. And that was signed Duane Youngblood. So then there is the other with Brad Sumner of the Sumner Law Group responding to Tyrone. Hi, Tyrone. Per the email from Duane below, I went ahead and drafted your withdrawal from the case. Upon your approval, we can file a same directly. Otherwise, we ask that you please file this within the next day or two. Thank you for your cooperation, Brad. And taking the taken. Ooh. Oh, that's the confidential notice. And that's the copy of Duane Youngblood, and this is the withdrawal level. Well, now after reading this email, we see that it appears that the Sumner Group was already aware of the issues with the case, and that might be why Tyrone Blackburn did not notify or say anything about the misquotations and everything because they was already aware of it. You all tell me what you all think about it. Do you think they were aware of what had been going on? Do you think that Tyrone Blackburn should be sanctioned and will be sanctioned by the court. What is your opinions on this? This is, getting really interesting. Remember, on the 24th, there will be, Tyrone Blackburn have to appear before the judge, and the judge is going to make his determination regarding the sanctions. And so, it is what it is. It's going to be an interesting thing. I'm going to double check and make sure nothing else had come in on this case today as I close out this video. I don't think anything else should come out on this case since filing this video, but you never know, because it is always something going on. I'm going to check this case right quick, make sure nothing else had come out on it since then. No. So what we're going to do is, want you to like, share, and subscribe. Turn on your notifications, because when the other case drops, as far as the judge ruling on sanctions on Blackburn, we're going to come live or do a video to let you know exactly what's up with this. All right, everybody, we thank you so much for tuning in to Save News TV. Please like, share, and subscribe. The playlist is in the description below and pinned in the comment section, so you can catch up with us. We appreciate you so much, and you have a wonderful and blessed day. Bye.
Getting bored? Want to enjoy some relaxing music? Do you need to get updated with all the latest news but don't have enough time to watch TV for hours? Or do you need to get your praise and worship on? We have your solution to your problem. SAVEDnewsRadio.com got everything you need. Listen to SAVEDnewsRadio.com, filled with praise and worship 24/7, everywhere, in your home, laptop, or tablet, on your phone, in your car, and on Alexa. Install the Save News Radio skill on Alexa, and then just say, "Alexa, launch Save News Radio." The beautiful, uplifting sounds of praise and worship music, ministries, news, and more. SaveNewsRadio.com, created to glorify God and edify the body of Christ.
I'm writing lines to lift his name, no need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe. To glorify the Most High, let's amplify. I am spreading the faith I hold so dear, for every tear he's ever near. Choirs rise on Sunday morn, his love we adorn. Each melody a testimony, hearts reborn. In every verse a whispered prayer beyond compare, to lift the hearts of those in dark despair. We testify with every note we sing, in harmony let freedom's bell ring. Rejoice and lift your voice, let the sound of praise deploy. Marching to his beat we go, face the seed we're here to sow. A standing strong through trials, love's chapter will compile. A beacon shining, grace defining across the mile. In our stories his glory shines a light divine. Through the gospel prove his truth we move, lives alive. Each Sunday pew, a vessel lined with grace anew. Souls intertwined, the word defined, it shines on through. Lifting high the cross we bear, in silence share. Hey, hey. The hymn we breathe, in him believe, it's love we declare. We're saved by grace voice in this old leopard place. Voice is strong and this soulful.